Lordship, kind permission, we mentioned serial number 22. In fact, Lordship had on 7th of March had put up this matter for today, just to know as to over bird view of the matter, and I had asked my briefing counsel to give a notes also, which I had.
Serial number 22.
22. If I'm only requesting Lordship, we have it at any time 12 or I'll just take 10 minutes. The two aspects to it, that whether Lordship would like to hear the matter before admitting it, whether it requires admission of this matter.
What is the impugned order?
Actually, the impugned order relates to a partition suit, a preliminary decree under the Muslim law, where the allegation of oral hiba was made, which the defendant has failed to prove. So therefore the suit
It has
was.
not yet been admitted?
It has not
Second
been
appeal.
admitted. No notice has been
It is
issued.
second appeal.
It is first
First appeal.
First appeal.
First appeal.
I appeal for the appellant already.
Yes, I'm only asking
You
for.
are for the appealant.
No, he's for the respondents.
I'm
I'm
so sorry.
sorry.
I'm sorry. I'm sorry.
You
So
will-
It has to be formally admitted, the records.
that's why, Lordship, for that matter only, I would like to make some submission. Lordship, fix it at 12 or 2,
You
whatever
have any
time.
objection
You
to
already
admission also?
Not on admission, Lordship. But I'm trying to basically make submissions that if Lordship, if there are 58 respondents they have made. 58. It will take a decade to serve the. Out of 58,
In Jharkhand, it doesn't take so much of time.
out of 58,
Yes.
43 I have my wakalat.
43. Okay.
I have
So
my
far as the
wakalat.
remaining are concerned, they are
15 are
residents.
remaining.
15 are remaining.
Out of that, 4 are mother and sister of the appellates. 55 to 58 are mother and sisters of appellate.
55 to रिकॉर्ड दिखाइए आपके पास फाइल है ना
Yes, I have.
आपको अभी फिल करना
I will just, I'm so sorry to trouble.
you have filed this synopsis. This is from your side.
Yes, Lordship, yesterday, Lordship, I had.
Respondent number.
This will be respondent number 1 to 3, contesting respondent, if Lordship could say.
Okay.
Contesting respondent. Because we were the plaintiffs there, some of the respondents.
Have you also prepared any note?
Your leadership, Mr. Gupta had to argue this case out.
That's right. Fair
No,
enough.
we haven't prepared.
Please
as yet.
do that. Please do that. As it is for first appeal, we have to hear everything. But you prepare your note, you can refer to the evidences. Normally evidences are in Hindi, so you can just put it in a translated manner, in a short synopsis. And we will certainly go through the evidences, but that synopsis is important.
Lordship, may I have one suggestion, if Lordship may permit me, that the trial court record,
Yes.
Lordship, in DB also in once I have made submissions, that I have the entire trial court record in certified copy.
I'll tell you. You be ready. When do you want? Everything will be done. Notice will also be served. We serve notices even through the police station.
Lordship, on 24th.
And once the notice, if that is why I wanted to know whether all other respondents who are not appearing, maybe their relations or whatever, or pro forma, we have to issue notice to
Yes,
them.
yes. Formally,
So,
notice has to
Formally notice has to go. Are they all residents of Jharkhand or they are residing outside?
They are in Bihar also, some.
Some
Some
of
are-
Jharkhand or Bihar.
Okay. So, in cases where those who are in Jharkhand, we can issue them notices through the concerned police station and also ordinary process.
No issue.
So, we'll have a service report through the police station, through the officer in charge of
Request
the
for
police station.
24th of April, because I have one matter, another here.
You don't need to worry about it. Further is that so far as people in Bihar is concerned, if the address is otherwise correct, we will issue the notice through speed post.
No issue.
And speed post delivery report will be tracked by our registry
No.
and they will put it on record.
Lordship, the only request that they must serve, because all are related, through Dasti also.
We'll do that.
That will, in
Will you
addition.
undertake to serve some
We'll
of
do
the...
that. We'll do that.
Okay, let us find out who can you serve through this.
Lordship, may record that respondent number 1 to 30,
1 to 30,
30 and 42 to 54.
42 to
54.
54
I have wakalat now.
are appearing.
I appear.
You have already appeared?
I have appeared. This wakalat nama has been signed. Will be filed during the course of the day.
Okay, you accept notice on that?
Yes.
Either you are in the process of filing
Yes.
wakalatnama or you have filed for
Yes.
some of them.
Process of filing.
Okay. So far as 31,
31 to 41 are
41.
concerned. There are 11 respondents. They need to be served. Apart from 31 to 41, 55 to 58
55 to 58
are the mother and three sisters of the appellant's hearing. They are the four brothers have filed the appeal, who were the contesting defendants before the trial.
They were the contesting.
They are the only contesting because it is their case that their father had hima in their favor by the grandfather. So they were the contesting.
55 to 58.
50. So 55 to 58 are the immediate family members of the appellant. 31 to 41 are the family members, but not the immediate. If Lordship could see, it's a very hodgepodge memo.
You don't need to worry.
And except both of us, all were proceeded ex parte. So we were the plaintiff there, they were the contesting defendants.
31 is Srimati Noor Jahan Khatun.
Yes, Lordship.
Kindly check because there is a
Yes,
change in
yes. I have checked it. She
Noor Jahan Khatun.
Noor Jahan Khatun,
Please,
she
please.
is the sorry. She is the sister of.
Please just
Sorry, I'm sorry.
You see 31, 38, 39, 40 and 41. They are residents of Jharkhand. Correct?
Please.
Yes. Rest are from Bihar. We'll take care. And so far as 55 to
55 to 58, they are also resident of Jharkhand and they are immediate family members.
you see, so far as 55 to 58 are concerned, they are the contesting respondents. Therefore, it is better if we serve them through the concerned police station and through online.
In addition,
Dusty.
that will be, I think, fine.
And
Because they
so
will
far
have,
as-
their prejudice will be to them.
Certainly. And so far as the other respondents from Bihar are concerned, you don't have any access to them.
That I have to get
They-
the instruction.
So okay, then we can ask for speed post. Right? Are you in a position to file the requisites during the course of the day,
No, today.
by tomorrow?
At least a week.
Oh, who is your senior?
Rahul Kumar Gupta.
He has got a big office.
No. He is not here due to some personal difficulties.
So he doesn't need to take steps. You are there for notices. He is a senior now.
We did for first 5 years all this.
He has crossed much more than that. Everybody, including page numbering, arrangement of documents, removal of defects. आजकल के जूनियर नहीं करते.
Very little distinction between clerks and first 5 years.
Clerk is the first senior of any
First group
council.
we call.
We are doing that.
Then it's your work. Do it by tomorrow.
At least a week. Because there are more than 50 respondents.
No. 43 we have already
Okay,
taken care
काम
of.
खत्म.
43 have taken care.
You see, it is going to be a very clear order. And further, you are required to deposit the special messenger cost for the purposes of calling for records. वो आ जाएगा, वो एक हफ्ता डेढ़ हफ्ता में आ जाएगा. I'll ask the court master to retain the records. और जब भी आप स्लिप देंगे आपको मिल जाएगा records for inspection. There is no problem. बस 24 तारीख को बहस कर लेंगे, उस दिन टाइम नहीं देंगे. ठीक है?
Will
Is
be
that
so
okay?
obliged.
First appeal file, it is defective.
That-
अच्छा. First appeal number 15 of 2025. Counsel for the appellant is present. Mr. Izzaz.
M.A. Niazi.
Sorry.
Ijaz Mahmood is different.
Sorry.
M.A. Niazi.
I'm so sorry.
No.
I've heard you for so long, but I just.
M.A.
missed
Niazi.
you. Mr. M.A. Niazi appears on behalf of respondent number 1 to 30 and 42 to 54, and he submits that Wakalatnama either has been filed on their behalf or it will be filed within a couple of days.
It will be filed within the nothing has been filed. I have checked it today. It is all original.
Okay. He undertakes to file Wakalatnama within a period of 1 week from today.
Much.
With respect to respondent number 31 to 41 and 55 to 58,
Yes.
the learned counsel submits that notice has to be issued to them. So far as respondent number 55 to 58 is concerned, though they were the contesting respondents, but they are close relative of the appellant, that is mother and sisters.
Immediate family.
The records reveal that so far as respondent number 31, 38, 39, 40, 41 and 55 to 58 are concerned, they are residents of the state of Jharkhand. Let notice be issued to the aforesaid respondents, that is respondent number 31, 38, 39, 40, 41, 55 to 58 under ordinary process as well as through the concerned police station, thusly in addition. The requisites regarding service of notice to them be filed with the notice court within a period of by Monday. So far as respondent numbers
Monday is a
Could be by Tuesday.
by
because
Tuesday,
there
Wednesday,
could be Eid on Monday.
within a
Okay.
period of 1 week. हो गया खुश? Okay. So far as respondent number कौन से बच्चे? So far as other respondents are concerned, they are residents of state of Bihar. In such circumstances, let notice be issued to them through speed post, for which requisites be filed within the period of 1 week from today. Office to track speed post delivery and prepare appropriate office note in connection with service of notice. At the request of the learned counsel for the appellant, let the records of the case be called for from the concerned court upon deposit of special messenger cost. आपकी request लिख दें? बताइए, कोई objection है आपको? We a special messenger cost. The special messenger cost we also deposited within a period of 1 week. Done. Since the learned counsel for the appearing respondents comes from Delhi, he has made a request that the matter be posted on 24th of April. Post on 24th of April. Are you otherwise कर लेंगे आप लोग? For final disposal, it will be open to the counsel for the parties to request the learned court master to have an inspection of the lower court records so received from the concerned court, and the inspection being made in the courtroom itself.
But there is one more request that what I feel and I see in Delhi also, when the record comes from the lower court, it is not paginated properly.
No,
So
it is always paginated. Always.
There we face that such problem.
यहाँ आपको ऐसा हो जाएगा. यहाँ को ऐसा. It is always paginated. Rather you can ask your junior कि वो accordingly paginate कर. जो हमारे कोर्ट का pagination है, उसके अनुसार pagination. यहाँ पे सारा pagination रहता है, index रहता है, flagging
they say
रहता
the
है,
requisite
list of
that
exhibits
these
रहता
many
है.
pages are.
सारा number of pages रहता है. यहाँ पे कोई you can have a look at any of the records. उसके बिना तो हो ही नहीं सकता.
Because
और फॉर्मल एडमिट कर दीजिए. ठीक है? आपका अपीयरेंस लिख दो. चलिए इनका अपीयरेंस डाल.
Much of it.
And before you ultimately argue, please verify whether parties have appeared, not appeared.
But in case not
The notices-
otherwise also,
Exactly. The notices should accompany a copy of the script. जिससे उनको भी पता चले कि उनको क्या करना
and in fact, Lordship, I need to because we are the caveator, caveat may be discharged.
है. Okay.
And they must supply me the proper a memo of appeal because we are
वो
not.
दे देंगे,
We'll do
दे
that.
देंगे ना?
I hope that without even order they can.
Okay,
give
the
us.
caveat has been filed on behalf of.
Worship, some of the respondents were filed
Okay.
and the names are there.
The caveat number 290 of 2024 has been annexed along with these records. The learned counsel for the appellant undertakes to provide a soft copy and also a hard copy of the entire records of the first appeal to the learned counsel at the following email ID. Mail ID दीजिए।
Niazi786@gmail.com.
लिख के दीजिए। एक भी डिजिट गड़बड़ हो जाएगा।
Niazi NIYAZI.
लिख के दीजिए। आपको मिल जाए। आप भी अपना written notes advance में फाइल करेंगे। You see, we start our hearing with the written notes, and after the conclusion of arguments,
In fact, Lordship,
are also
give us that
permitted to
liberty.
file a. That
Yes.
is always there. A revised note, because there can be many points which you would
judgments.
like to cover.
Yes, because
that
these are
time.
only given for the bird's view,
Yes.
so that Lordship can understand.
You can file your at least the judgments which you are seeking to rely upon. You should file it in advance. But after the conclusion of the argument, if there is any revised note you want to file, pursuant to whatever you have argued
Yes.
in the court, that
whatever the
permission is
queries
there.
of the court.
बस एक ही चीज का ध्यान रखने की जरूरत है, रिकॉर्ड के बाहर कुछ ना बोले और जो बहस नहीं किए हैं वो कुछ ना बोले। अगर ऐसा कुछ रहता है
Unfortunately,
तो
no.
मैं बस उसको
Lordship,
रिजेक्ट कर
the fortunate part is that I was the counsel who argued the matter finally before the trial.
Oh, so you know
So
the
my
entire
written
matter.
arguments are there, and what I have given today is the gist of what I had filed.
Okay.
So there won't be any deviation from that.
और कोई
Not even a
24
single
कोई
point.
खास मैटर प्लीज
Appeal.
24th अप्रैल को क्या बेंच रहेगा आई कैन नॉट से बेंच तो कल का भी नहीं पता किसी
But
को
that-
और दैट मैटर
Nobody can say that.
बट अगर ये कोर्ट रहेगा तो हम लोग इसको सुनेंगे
Because I want to give that time for notice service of notice.
There are
because
only
many
few
holidays also.
cases on Muslim law which we have opportunity to hear.
This is
So,
very, Lordship, a
The
very-
more the contested case it is, the more clarity the law will be there.
And in fact, Lordship, I bought the mullah for this case, and I was enlightened on so many parts which I was not aware.
Must have.
Because there is a concept of partial partition in Muslim law which is not there in Hindu law. So suppose there are 4 properties, I can go for partition of one only, not all 3. In Hindu law, you cannot do that. The second concept is all the legal heirs are tenants in common. They are not the co-parceners. So there are different concepts which I really learned in this matter.
We'll also learn.
So much of it.
2:15 बजे रखें at 2:15.
I do. Much of it. So much obliged for the indulgence.
For the supplementary list for hearing, I can close this case. First appeal 64 of 2015.
Respondent आए हैं.
Then for respondent number 6.
You are for respondent number? Straight. आपको कुछ बोलना है?
I will adopt the argument hearing with this state also. Lots of permit, I will submit written notes.
अब क्या आप तो लिखा है?
I will adopt it.
अब क्या written notes होगा?
नहीं कल हम आने को सुना की तबीयत खराब थी उसी में चले गए इसलिए हम फिर बहस हो गया
कि आज तो वैसे भी लगता है कि बहुत सारे मैटर्स नहीं ही टिकट हो रहे। आप किस मैटर के लिए आए हैं? फॉर एडमिशन कल से जो आए हैं फॉर फाइनल हियरिंग है आपके अदर साइड है क्योंकि अभी एक शीज अच्छा हाँ शीज प्लीज होल्ड ऑन लेट मी जस्ट फिनिश इसको लिखा के आपका करेंगे आप लोग को जहाँ भी कुछ बोलना है आप लोग नोट कर लेंगे, बीच में डिस्टर्ब नहीं करेंगे. माई स्टेनोग्राफर ऑल्सो गेट डिस्टर्ब. और एक जगह नोट कर लेंगे और जब हम आपसे पूछेंगे कि यहाँ पे आपको कुछ बोलना है क्या, देन यू जस्ट इंडिकेट, वी विल रेक्टिफाई इट. अपना अपीयरेंस मेमो दे दीजिए. This appeal has been filed against the judgment and decree dated 29/6/2012, within bracket decree signed on 13/7/2012, passed by learned Subjudge Roman 4 Senior Division Bokaro in title suit number 3 of 1987, whereby the title suit filed by the appellant has been dismissed. The learned counsel for the parties have extensively placed the plaint and written statement of the respective parties. The suit was originally filed by Tikayat Ramlakhan Singh. नहीं क्या है? Tikayat Ramakant. Okay. Tikayat Ramakant Singh, son of late Tikayat Rameshwar Narayan Singh. Against the state of Bihar and others. The specific case of the plaintiff was that Raja Kunj Bihari Singh Tikayat of Bharmahal estate, by grant of Jodh Patta in the year 1893, made a Rayati settlement in favor of one Chantu Singh with respect to property under Mauza Titliya Thana number 38, total area 345.50 acres of Kevat number 4/124/10, Khata number 20-261, and 35 acres of Khata number 1 of Kevat number 2 of the said Mauza, except Bharaberi Chalkland.
Kevat number 4/9 and 4/10. 4/1.
Sorry, 4/9 होना
4/9.
चाहिए. At this stage, the learned counsel for the plaintiff, who is the appellant before this court, has indicated that the Kevat number is actually 4/9 and not 4/10.
4/9 and 4/10, not 4/1.
4 by The Kevat number is 4 by 9 to 4 by 10.
4 by 9 and 4 by 10.
4 by 9 to 4 by 10 एक ही बात है. 4 by 9 to 4 by 10 and not 4 by 1 to 4 by 10 as mentioned in paragraph 1 of the plaintiff. Was that Chamtu Singh died prior to survey of 1922. His here Sahib Ram Singh and others became the Khevardars of Mauza Tetulia under aforesaid Raja Tikayat Kunj Bihari Singh. Sahib Ram Singh and others defaulted in payment of khazana to the aforesaid Raja, and Sahib Ram Singh and others by a registered deed of surrender dated 25/11/33 surrendered 345.50 acres of land. Aforesaid 345.50 acres of land in favor of Raja Manmohan Singh Tikayat, son of Tikayat Kunj Bihari Singh, and consequently Raja Manmohan Singh came in khas possession of the aforesaid property and which became his Bakast land in 1933. It was the further case of the plaintiff that by a registered deed of settlement, ये registered लिखे हैं 7134 है ना paragraph. By a registered deed of settlement dated 7/134, Raja Manmohan Singh Tikayat, who was the successor of the Raja, of the earlier Raja, made a Rayati settlement in favor of Shri Nalini Kishore Ghatwalin, widow of Sahib Ram Singh, Reshma Kumari Ghatwalin, widow of Chattu Singh, Upasi Ghatwalin, wife of Dukhi Singh, Srimati Kumar Chatwalin, wife of Kangla Singh, an area of 27.66 acres of the said Mauza by registered deeds. However, the rest of the aforesaid Bakast land in Mauza Tetulia, that is remaining, that is 317.82 acres under Kevat number 4 by 9 and 4 by 10. ऐसे लिखिए, the rest of the Bakast land of Mauza Tetulia, that is 317.82 acres the said Raja Manmohan Singh made a Rayati settlement in favor of sons of Rameshwar Narayan Singh Tikayat, within bracket, father of the original plaintiff, bracket close, by a deed of settlement dated 8/4/34 and put the father of the plaintiff in possession thereof. It was therefore the case that after settlement, Rameshwar Narayan Singh Tikayat paid rent and was granted rent receipts by the Raja. The plaintiffs are concerned with the property which is covered by the so-called settlement deed dated 8/4/1934. However, during the course of hearing, the learned counsel for the appellant has submitted that the settlement deed is dated 9/4/34 and not 8/4/34, and it has been and the date has been wrongly mentioned in paragraph 5 of the plaint. Correct? It was the further case that right from the date of settlement in the year 1934, the plaintiffs entered into an agreement for sale for 312.82 acres of land with different persons on valuable consideration in the year 1940, and received payment in advance by way of part performance of agreement, as the possession was delivered to the respective persons. And those persons have constructed their residential houses on the property and are living on the same. It was further case in the plaint that pursuant to the said settlement, the father of the original plaintiff, in favor of the father of the original plaintiff, Raja Manmohan Singh Tikayat, opened a Jamabandi bearing Jamabandi number 61 in his favor, and the father of the original plaintiff started paying rent against the Rayati settlement, and one of the rent receipts granted to the father of the plaintiff for payment of rent for the year 1937 was of the year 1937 within bracket Bangla Samvat 26 Posh 1340 BS. Raja Manmohan Singh Tikayat in the year 1946 Bangla Samvat within bracket about January 1939 bracket appointed Sri Kamal Lal Maheshwari as managing agent for the collection of rent. The plaintiff's father also the father of original plaintiff also paid rent to the said managing agent against Jamabandi number 61. The further case of the plaintiff was that there was a loan of rupees 35,000 against Raja Manmohan Singh Tikayat, and by virtue of powers under section 2 of Chotanagpur Encumbered Estate Act 1975, the estate of Raja Manmohan Singh was taken over by the wards and encumbered estate, and it was an encumbered state. Manbhum was entrusted with the management of Bhar Mahal estate. A reference of the notification dated 1021 W dated 13/7/34 1939 has been made. And it has been stated in the plaint that the proprietary interest of Raja Manmohan Singh and Zamindar of Bharmahal estate and the management of the said estate vested in the said manager of ward and encumbered estate. The ward and encumbered estate of Bharmahal estate continued under the management of manager of aforesaid general manager even after enactment of Bihar Land Reforms Act 1950. And in this context, a reference has been made to a memo issued by the Deputy Commissioner as contained in his letter number 51W dated 29/10/1956. And it was stated that as per the letter, the estate of Bhar Mahal had not vested under Bihar Land Reforms Act 1950 as there was no notification under the Land Reforms Act for vesting. Consequently, the plaintiff's predecessor in interest continued to be the estate in respect of Jamabandi number 61 during the period of management of the encumbered estate till 1958. 58 or 56 till 1956. The notification under Land Reforms Act 1950 was made applicable to the district of Manhoon sometimes in the year 1956. The plaintiff's predecessor in interest in the capacity of Rayat started making payment of rent with respect to Jamabandi number 61 to the state of Bihar, and Jamabandi number 61 was opened pursuant to Bihar Land Reforms Act 1950. It was a specific case of the original plaintiff that by acceptance of rent from the plaintiff's predecessor for Jamabandi number 61, which continued till the date of settlement in favor of the father of the plaintiff which continued since the date of settlement in favor of the father of plaintiff in 1934, the Rayati right of the plaintiff's ancestor was duly accepted and acknowledged by the state of Bihar. The father of original plaintiffs died on 11/4/1969, and the plaintiff stepped into the shoes of his father and succeeded his properties, including Jamabandi number 61. The further case of the plaintiff is that in the month of October 1983, a house construction cooperative society was formed under the name and style of Tikayat Manmohan Singh Cooperatives House Construction Society at Jas district, Dhanbad. And the original plaintiff was a shareholder in the said cooperative society and made a transfer of 0.39 acres of his Rayati land to the aforesaid House Construction Society, which was registered, which was a registered society under Bihar and Orissa Cooperative Societies Act. It was the further case that one Bari Housing Construction Cooperative Society purportedly purchased about 10 acres of land from the aforesaid Rayat and his successor dated 7/1/34 by virtue of a registered deed of settlement in favor of heirs and successors of Sahib Ram Singh. When the said cooperative society made an application for the plaintiff asserted that the aforesaid PROF क्या है? Professor?
Yes, Professor Bari.
Professor Bari Housing Construction Cooperative Society made an application for settlement of land which was claimed to be the Rayati land of the plaintiffs by the plaintiff with respect to Jamabandi number 61 and Khata number 34 to 61 of Mauza Tatilia Chas by treating the said land to be government land. Pursuant thereto, an inquiry was conducted by the circle officer and a report was prepared. It was asserted by the original plaintiff that the circle officer charged without any inquiry from the plaintiff submitted a report on 22/7/1983 although the rent receipts was being granted in connection with Jamabandi number was being granted in favor of the father of the plaintiff in connection with Jamabandi number 61. The report suggested that Khata was Abad Malik of Raja Manmohan Singh Tikat and the circle officer reported that the rent of the aforesaid khata should not be accepted from the plaintiff. And it has been stated that the said order has been mentioned in Jamabandi Bahi of Jamabandi number 61 and also memo number 1372 dated 12/7/1984. The further cases, that report was placed before the Land Reform Deputy Collector who forwarded the same to defendant number 3 for consideration, and a proceeding was initiated for cancellation of judgment. It was a specific case of the plaintiff that the concerned defendants had no jurisdiction to initiate any proceeding for annulment or cancellation of Jamabandi number 61 under purported exercise of power under section 4 H of Bihar Land Reforms Act. And it was also stated that the settlement, the royalty settlement made in favor of the plaintiff's predecessor in interest, that is father of the original plaintiff, was much prior to the cut-off date mentioned in section 4 of Bihar Land Reforms Act, that is much prior to 1/1/1946. In the said background, it was stated by the original plaintiff that the defendant number 1 to 5 had no jurisdiction to declare the royalty land of the plaintiffs to be government land in absence of any acquisition under land acquisition or other provision of law, and that the plaintiff's royalty interest conferred by virtue of settlement dated 9/4/1934 cannot be extinguished by executive orders without any decree or declaration passed by a competent court. It was their further case that when the proprietary right of ex-intermediary of the plaintiff, having not been vested under Bihar Land Reforms Act in the state of Bihar, and in absence of any notification under section 3 of Bihar Land Reforms Act 1950, the right of the plaintiff over the land as rayat cannot be effected by orders of the executive officer of the state of Bihar. It was also asserted that there was no allegation that the royalty settlement done in favor of the plaintiff's predecessor in interest in 1934 was with the object to defeat the provisions of Bihar Land Reforms Act, and consequently it was asserted that the report and the recommendation of the circle officer of the respondent authorities for initiation of proceeding for settlement and stroke or settlement in favor of third parties and stroke or for cancellation of Jamabandi of the original plaintiff were illegal and vitiated. It was also asserted that the defendant number 1 to 5 had no jurisdiction to recommend for cancellation of Jamabandi running in favor of the plaintiff's predecessor in interest consequent upon vesting of land under Bihar Land Reforms Act 1950, when there was no appeal against the order for opening of Jamabandi by the state of Bihar in favor of the plaintiff's predecessor in interest, and the concerned defendants cannot be allowed to do indirectly, which cannot be done directly. It was their further case that the plaintiffs had acquired the royalty right under section 21 of the Jharkhand Tenancy Act, and the right cannot be effected in pursuance of section 22 of the Jharkhand Tenancy Act, and the defendants cannot refuse to accept rent from the plaintiff. it was also disclosed in the writ petition, in the plaint, that the plaintiff had moved the High Court under writ jurisdiction in CWJC number 120 of 1985 within bracket R, seeking to quash the proceedings which was contemplated by the circle officer. However, the High Court by order dated 2285 however, the writ court finally heard the matter on 29/4/85 and disposed of the case with an observation that the question of fact involved in the case must be the question of fact was involved in the case, and therefore the plaintiff must file a title suit. The matter was taken up in appeal before the Honorable Supreme Court, and which was also dismissed by the order dated 11/12/1986 with an observation that the plaintiff must file a title suit to establish his right to the property in question, and also ordered that till the filing of the suit by 5th of January 1987, status quo as regard to the land be maintained. It was the case of the plaintiff that the order of cancellation of Jamabandi was passed without notice to the plaintiff and without any show cause. Cancellation was done already,
Yes,
was without any notice and without any show cause.
on 14/8/84, 14/8/84.
The counsel for the appellant at this stage has submitted that the Jamabandi was cancelled by the order dated
14th August 84,
14th of August 1984. Exhibit,
not executed.
though that document has not been exhibited before the learned court. Considering the urgency of the matter, it was asserted by the plaintiff that in view of the urgency, the plaintiff was not in a position to give a notice under section 80 of CPC to the state government and its authorities, defendant number 1 to 5, and it was asserted that necessary leave be granted to the plaintiff to institute the suit without service of notice under section 80 of CPC. The learned counsel for the appellant has submitted that the necessary permission was duly granted. मिला था ना आपको?
Yes,
Granted for filing the suit without giving the notice under section 80 of CPC by order dated.
first order reflects law. The complaint is filed today with the nominal court fees. Registrar plaintiff filed a petition A for admission, file a suit without serving a notice, ATCPC, and also filed petition paying for time and file deficit court fee. Time is allowed till 21. Put up for admission with report of the
तो
solicitor.
यहाँ पे खाली लिखा है कि है, लेकिन कहाँ है कि you were exempted? When were you exempted? When was the case admitted? ऐसा तो कोई ऑर्डर नहीं, हाँ? सोच लीजिए, हम दिखा रहे हैं, ऐसा कोई ऑर्डर नहीं। अब देख, the learned counsel for the appellant during the course of hearing has gone through the order sheet. During the course of hearing has gone through the order sheet and has submitted that the plaint was filed with a petition seeking exemption of serving notice under section 80 CPC. However, no order allowing such petition has been pointed out by the learned counsel for the appellate. आप बता देंगे तो हमें। The suit was filed on, what is the date of filing suit? In the first week of 1987, है ना? The next date है 187 का कोई date है।
5187.
On
5187.
on 5/187. The records of the case reveal that there have been certain amendments in the writ petition, in the plaint with respect to party position, correct? And not with respect to any pleadings in the plaint. Originally in the plaint, only five defendants were there or 6 defendants?
Already 6 depends.
Originally 6 defendants were there in the plaint, including 1 to 5 were state of Bihar and their authorities, and respondent number 6 and defendant number 6 was Professor Bari House Construction Cooperative Society, in whose favor who had filed an application for settlement of the suit liability. Subsequently, the other defendants were also added. And total defendants in the suit were how many persons?
Total 9.
पढ़ा ही नहीं रहा आपका इतना पुराना रिकॉर्ड है बताइए how many defendants where total defendants in the suit were
In the order sheet it is
10. 10 defendants who were 7 to 10 who were 7 to 10 आप किनकी तरफ से हैं
हम प्रोफेसर बारी को
बारी को बाकी लोग कौन why were they made party 7 to 10
Yes, they filed an application for addition under Order 1 Rule 10 law.
Okay.
And this
Upon filing an application under order 1 rule 10
and this is order dated 28/6/89 law.
and were added respondent by the order dated 28/6/89
Plus one correction. Total 9 respondents not इसमें serial mistake 8 got selected लिख दिया total 9 respondents
total 9 defendants although the numbering of the defendant in the impugned judgment is incorrect in as much as after defendant number 8 the defendant number 10 has been mentioned. कौन सा ऑर्डर से बताइए कौन से ऑर्डर से वो impugn हुआ?
Order 28/6/89 law.
Order dated 28
6/89.
6/89. What was the ground?
They filed an application under Order Rule 10 law.
What is the ground? On what ground?
They are claiming law that they are the step brothers of
Okay.
Ramakant Singh.
The
Original
the defendants who were added by the order dated 28/6/1989 claimed to be the co-owners of the suit property. Correct? The defendant number one to 5 had filed a written statement. आपका भी written statement था? The records reveal that altogether 3 set of written statements were filed. One by defendant number 1 to 5, another by defendant number 6, and third by by defendant number 7 to 10. So far as the defendant number 1 to 5 are concerned, it was asserted that there was no cause of action, semicolon, suit was barred by limitation, semicolon, plaintiff had no locus to institute the case, semicolon, the suit as claimed was not maintainable, semicolon, it was barred by waiver, estoppel, accusations, semicolon, barred by the provisions of specific relief act, semicolon, and the plaint was not verified in accordance with law. Full stop. A specific objection was taken that the suit was barred for want of notice under section 80 of Code of Civil Procedure, and it was asserted that plaintiff was never in need of any urgent or immediate relief, and therefore the benefit of clause 2 of section 80 of CPC, and therefore he was not entitled for benefit of clause 2 of section 80 of CPC. It was also asserted that the suit was instituted long back, but the plaintiff never pressed for grant of interim relief by way of temporary injunction, which goes to show that there was no need for any immediate or urgent relief in the suit. It was asserted that the plaint itself was liable to be returned for fresh presentation after due compliance of the mandatory provision of law. Further objection was taken that the suit was grossly undervalued and court fees was insufficient. And that the description of the suit land was vague and also incorrect. The plea of res judicata was also taken. However, no foundational fact with regard to res judicata was mentioned. The defendant number 1 to 5 also gave para-wise comments to the suit. It was asserted that the plaint was not accompanied with the alleged Rayati settlement of the year 1893. And that the last survey settlement had not accepted the alleged settlement of the year 1893 in favor of Jamtu Singh. The statements of the plaintiff was denied. Jamtu Singh or his descendants, the Rayati settlement was alleged to be false and manufactured and denied. It was also asserted that if there was any settlement in the year 1893, the survey record of right published in the year 1922 must have mentioned the name of the settlee. And in absence of such mention in the survey record of rights, the normal presumption would be that there was no settlement at any point. It was also asserted that the cadastral survey settlement operation held in the year 1922 had accepted the descendants of Jamtu Singh as Kevatdar of Kevat number 4/1 to 4/10 in Kevat number 20 to 60 of Moza Tetulia. And therefore it cannot be said that Jamtu Singh was holding Rayati right over the land in question. With respect to Khata number 61, it was asserted that in the record of rights, it was Sheikh Imam Box Hoga under Kevat number 5. It was recorded in the name of Sheikh Imam Bucks under Kevat number 5. Raja Manmohan Singh was recorded as Kevatdar of 35 acres of land in the nature of Gair Abad Malik of Khata number 1 and 2. And all the statements made contrary by denied. It was asserted that the alleged registered surrender deed dated 25/11/33 is not a surrender of any rayati interest, but it was surrender of the tenure interest held by Khevardars. And that none of the land at any point of time was the Bakast land of Raja Manmohan Singh, and neither the plaintiff's father nor the plaintiff were ever in possession of any part of the said land at any point of time. It was submitted that after surrender of tenure right by Khevardars in the year 1933, there remained no tenure holder. And the right of availing privilege of non-paying rent on Abad Malik Bakas land and Gair Abad Malik was seized. It was further asserted that the rent of the other land measuring a total area of 27.88 acres comprising in Khata number 20 to 33 was fixed and made rayati settlement. And other registered deed of rayati settlement were also mentioned. With respect to other properties, and it was asserted that the rayati settlements made through registered deed was followed by payment of rent to Raja Manmohan Singh, ex-landlord, and to generally encumbered estate before vesting of Jamindari, and their transferee rayats were paying rent to the government of Bihar after vesting of Jamindari till date. It was asserted that the statements of paragraph 5 of the claim was categorically denied, and it was stated that the rayati settlement said to have been made by Raja Manmohan Singh in favor of the father of the plaintiff, in favor of his son, namely Rameshwar Narayan Singh Tikayat, with respect to 317.82 acres of land under Kevat number 419 and 4110 in Khata number 34 to 61 and 35 acres in Khata number 1 and Kevat number 2 was collusive and antedated settlement, incapable of creating any rayati right. It was also asserted that unless the plaintiff filed the alleged deed of settlement dated 8/4/1934, it was not possible for the defendant number 1 to 5 to explain the position. And the defendants reserve their right to file additional written statement as and when the said documents are produced before the court. it was asserted that neither the plaintiff nor his father was at any point of time possession of any portion of the aforesaid land. And it was aforesaid land claimed by them, and it was asserted that the land in Khata number 61 are Abad Malik land of different tenure holders, and after vesting of zamindari under the provisions of Land Reforms Act, ये मत लिखिएगा, लास्ट में इट्स रिपीटिशन टाइप का. ये यहाँ लिखे ना, खाता नंबर 61 are Abad Malik land of different tenure holders. It was the specific, full stop कर दीजिएगा. It was a specific case that no part of the land shown in the schedule of the claim was settled either in the name of the plaintiff or in the name of his father. It was also asserted that neither the plaintiff nor his father or his alleged transferees were in possession of any part of the land, nor they have constructed any building over the same for residential purposes. It was further stated that the relevant rent receipts were not annexed with the plaint, and even if any rent receipt has been granted by the Karamchari or revenue employees, that the same will not take away the right of the government. It was also stated that the estate of Bharmahal of Raja Manmohan Singh was taken over by ward and encumbered state, and a manager was entrusted with the management of the same till 28/11/1957, after which it vested in the state of Bihar free from all encumbrance. It was also stated that there was neither any existence of notification dated 13/7/1979 nor the existence of Chota Nagpur Encumbered Estate Act 1975, under which the estate of Bharmahal was taken by the ward and the encumbered state. It was stated that the estate of Bharmahal had already vested in the state of Bihar with effect from 28/11/1957. It was stated that in the year that there was no existence of Manbhumi district in the year 1979 also. With respect to para number 12, which mentioned about the letter, the defendants reserve their right to file additional written statement when the letter in question will be filed by the plaintiff. And in absence of the letter, the defendants were not in a position to either accept or deny the same. The written statement filed by defendant number 1, 2, 5 reveals that there was a serious objection in connection with non-filing of documents which were mentioned in the plaint along with the plaint, and the said defendants have repeatedly reserved their rights to respond to the same as and when such documents were filed before the court. The existence of such documents were denied, and it was also stated that if such documents were at all existing, the same were collusive and it was also asserted, same were collusive. It was also asserted that it was also denied that any rent was ever collected from the plaintiff or his father on behalf of the state of Bihar, nor any rent receipt has been granted to them at any point of time. The plaintiffs, it was asserted that the plaintiffs had succeeded in getting one Jamabandi number 61 opened under Khata number 59 in collusion with the revenue Karamchari without any order from the competent authority, nor there was any basis of showing collection of rent. The matter was inquired into thoroughly, and lastly, the said fabricated Jamabandi was cancelled on 14/8/1984 under the orders of the competent authority.
Speed हो रहा है litigation. हमारी speed.
It's a कहाँ छूटा बताइए?
ये तो हम यहाँ से लिखेंगे next time थोड़ा सा slow.
नहीं हम फिर से बोलो. It was denied that any rent was ever collected from the plaintiff and his father on behalf of the state of Bihar, and that no rent receipt was granted to them at any point of time. It was asserted that the plaintiff had succeeded in getting one Jamabandi number 61 opened under Khata number 59 in collusion with the revenue Karamchari without any order from the competent authority, nor there was any basis of showing collection of rent. The matter was inquired into thoroughly, and lastly, the said fabricated Jamabandi was cancelled on 14/8/1994 under the orders of the competent authority. ठीक है? Sorry?
Yes.
It was further stated that the Tikayat Manmohan Singh Cooperative House Construction Society at Chas was established in the year 1983, and the statements made in connection with the same was said to be the internal matter of the plaintiff. And the aforesaid society, and the transfer of 0.39 acres of land by the plaintiff to the aforesaid society could not be ascertained unless full details are furnished by the plaintiff. It was also asserted that even if it was done, the same will not take away the right of the state, nor could establish any title in favor of the plaintiff. With respect to defendant number 6, it was asserted that the defendant number 6 had purchased some land from the established Rayat or their successors, and a proposal for resettlement of land with respondent number 6 was made for 10.65 acres in Khata number 39, which was adjacent and surrounded by the other land of the state society. and the same was under the process of settlement. It was also asserted that the land of Khata number 59 are Gair Abad Malik land and are under the physical possession of the state of Bihar, and the plaintiff had no right, title or possession over any part of such land. And that thorough inquiry in connection with the claim of the petitioner was made. And thereafter the Jamabandi was cancelled, which was fraudulently opened. The filing of the writ petition and that the matter went up to the Honorable Supreme Court is not in dispute. However, the assertion made in the plaint with regard to the direction of the Honorable Supreme Court, as mentioned in paragraph 42 and 43, it was stated that the defendant number 1 to 5 were not aware of such direction, and it was again reiterated that the notice under section 80 of the CPC was mandatory and the plaintiff should have complied with the same before filing the suit. ये exhibit हुआ है Supreme Court का order? However, during the course of hearing and upon a query made by the learned counsel to the learned counsel for the appellant, he has fairly submitted that the order passed by the Honorable Supreme Court has not been exhibited before the learned court. Writ का order exhibit हुआ है? Even the order passed by the writ court in CWJC number 120 of 1985 in bracket R has also not been exhibited before the court. With respect to valuation, it was asserted that the market value of the property was more than rupees 35,000 per acre, and unless the suit is valued afresh, it could not proceed. So far as the written statement of defendant numbers 7 to 10 is concerned, they were primarily claiming that they are the descendants of the common ancestor with respect to the properties recorded under Khevat number 4/1 to 4/10 having area of Mauza Tetulia having area of 345.50 acres under the then Raja Kund Bihari Singh Tikayat of Bharmahal estate. It was their specific case that the properties held and possessed by Raja Manmohan Singh was never settled in favor of the father of the plaintiff, and the deed / paper dated 8/4/1934. By virtue of the deed / paper dated 8/4/1934 or any date whatsoever, the paper, if any, is not showing the alleged settlement in favor of the father of the plaintiff, and the same is fraudulent, collusive, or manufactured document. It was asserted that by virtue of the alleged settlement, the father of the plaintiff did not and could not acquire any manner of right, title, interest in respect of the properties. A reference was also made with respect to one title suit, number 16 of 1986, which was pending. Further genealogy was also given of Kunj Bihari Singh, the then proprietor. With further division of share of the property. The claim of the plaintiff in the plaint in entirety was denied by the defendants with respect to the suit property and the basis of such claim. It was stated that the plaintiff had no right whatsoever to transfer the alleged property in favor of the society in the style of Tikkai Manmohan Singh Cooperative Society, and such transfer, if any, is illegal and inoperative. It was asserted that in title suit number 16 of 1986 filed by the defendant seeking partition of the share in the properties and it was pending. It was categorically stated that the plaintiff or his father never held or possessed any portion of the suit property in exclusion of the other defendants, other descendants of Manmohan Singh, and that too the alleged Jamabandi number 61 and they were not exclusive owner of the property. So far as the defendant number 6 is concerned, the written statement of defendant number 6 was in the same line as that of the state, correct?
Yes,
Same line में था?
almost.
The counsel appearing on behalf of respondent who was defendant number 6 in the suit has confirmed this fact during the course of hearing that the stand of defendant number 6 was almost on the same line as that of the state, and during the course of hearing also he has adopted the arguments of the state. The learned trial court framed as many as 6 issues. Which are as follows. And the plaintiff examined 9 witnesses. These details are as follows. Para 8 से ये जो है ना issues है para 6 में, सॉरी, documents है para 7 में, इसमें कोई error तो नहीं है. उसके बाद para 8 में है number of witnesses. So far as the defendant number 1 to 5 are concerned, they examined 5 witnesses. On behalf of defendant number 7 to 10, 5 witnesses were examined. And the following documents were exhibited. Para 9 and 10. कितने witness किसकी तरफ से examined हुए? On behalf of defendant number 7 to 10, 5 witnesses were examined. है ना? Defendant number 8, अलग से नहीं पता चला. ये पैरा नंबर 11 में भी है कंटिन्यूएशन में. 10 and 11 में डिफेंडेंट के विटनेसेस एग्जामिन जितने हुए हैं वो लिखा हुआ है. The trial court decided all the issues against you?
Yes, sir.
Decided all the issues against the appellant. And the main issue which fell for consideration was issue number 8 and 9, which was decided by para 12. Para 12 हम दिखाएंगे अलग से main issue, और para 13, 14, 15 and 16 को as it is quote कर देंगे. It was decided in the following way. The learned counsel for the appellants during the course of hearing has submitted that the main issue was issue number 8 and 9, and non-filing of the original documents, particularly the rent receipts said to have been issued prior to vesting, and also the deed of settlement dated 8/4/1934, in bracket actual date 9/4/1934, was well explained by virtue of the evidence of PW1. he has submitted that PW1, who was the who claimed to be the authorized agent and also the lawyer cum legal advisor of Mathur Raj family since 1949, had asserted that he was in possession of the various documents including the unregistered patta dated 9/4/1934 and also the original rent receipts. Was in the hospital from 22 to 1991 to 13/3/1991 in Purulia nursing home, and when he returned back, he found that the documents were missing. It was his further deposition that on 14/3/1991 he had sworn an affidavit before the notary public with respect to loss of documents, which was marked Exhibit 2. The Learned Counsel has submitted that Exhibit 2 was more than sufficient, read with the evidence of PW1, to say that the documents on the basis of which the plaintiff was claiming title over the suit property, that is, the settlement of the dated 9/4/1934, was lost. We have submitted that the photocopy of the said document was exhibited and the same was marked without any objection, and consequently those documents ought to have been taken into consideration for the purposes of deciding the case. The Learned Counsel has further submitted that had those documents been taken into consideration, then there was no reason not to decree the suit filed by the plaintiff. The Learned Counsel has also submitted that a photocopy of the letter number 51 dated 29/10/1956, which was referred to in the plaint, was also produced and marked X for identification. But the same was also not taken into consideration to decide the case. The Learned Counsel has also submitted that had also referred to paragraph 17 of the present memo of appeal and has submitted that plaintiff had filed certain certified copies of Mandhu settlement case number 125 of 1934-35, wherein a reference was made to the aforesaid settlement dated 9/4/1934, नहीं सिर्फ इतना ही नहीं. The file certified copy of Manroom settlement case number 125 of 1934-35 along with the petition for marking the same. But the said document has neither been marked nor has been taken into consideration. However, from perusal of paragraph 17 and during the course of argument, it appeared that the statement was vague as no specific date of such filing was mentioned. However, the learned counsel for the appellant, while looking into the order sheet, has stated that the paragraph 17 was referable to order dated 6/11/1992. The fact remains that all the evidences were adduced after 6/11/1992, but none of the plaintiffs had exhibited the Manroom settlement case number 120 order of Manroom settlement case number 125 of 1934-35, and even from the records as received from the learned court, no such petition, no such document has been found. However, it is not in dispute that the said document was not marked as an exhibit. By any of the witnesses. And consequently, the same was nailed. It has also been pointed out by the learned counsel for the appellant by referring to para 13 of the memo of appeal that there was no requirement for a patta to be registered when it comes to agricultural land. And he has submitted that however, it is not in dispute during the course of hearing that the so-called patta dated 9/4/1934 and also the rent receipt and also the couple of rent receipt which was said to have been issued prior to vesting and said to be in Bangla were never produced in original before the learned court and photocopy was produced. With respect to requirement of notice under section 80 of CPC, no arguments have been advanced by the learned counsel for the appellant. Although there is a finding by the learned court that the suit was barred on account of non-furnishing of notice under section 80 of CPC.
The same is stated in the plate notes.
Sorry?
The same has been stated in my plate notes.
तो आपका प्लेंट आपको सुने तो आप बताइए, आप तो कोई बहस नहीं की.
So mention किए हुए हैं कि there is no requirement of leave के लिए भी हम application file किए. So the finding given by the
लेकिन
director-
नहीं ना दिए हैं आप कुछ. However, at the time of dictation of the judgment, the learned counsel for the appellant has submitted that an application for leave to file the suit without furnishing notice under section 80 of CPC was filed, and it has been stated in the memo of appeal that such leave was granted. But from the records of the case, the learned counsel for the appellant has not been able to point out any order by which such leave was granted. And consequently, it appears that the case proceeded without granting leave or filing the suit in absence of notice under section 80 of CPC. It also appears इस कहानी को यहीं खत्म करते हैं, ठीक है, ऊपर नीचे होगा डिक्टेशन में, ठीक है. It also appears from the record, it also appears during the course of argument that the order of the Honorable Supreme Court was not exhibited before the learned court, although it was pleaded in the suit that interim injunction in favor of the plaintiff was granted only till 5/1/1987, which is the date on which the suit was filed, and that was the reason for not furnishing notice under section 80 of CPC. However, the said order of the Honorable Supreme Court was not brought on record, and consequently this fact could not be proved. The fact also remains that the plaintiff did not move for any immediate relief of temporary injunction before the learned trial court for a considerable period.
Injunction petition was filed before the.
But you never moved. And this fact has been taken care of the learned trial court. And it has been held that the suit of the plaintiff was barred on account of non-filing of notice under section 80 of CPC. सेक्शन 80 पर बहुत नए नए जजमेंट्स आए हैं, आपको पता नहीं होगा, काफ़ी जजमेंट्स आ रहे हैं सेक्शन 80 पर, इट इज़ मैंडेटरी. आई विल साइट वन जजमेंट, इट वेरी रिसेंट, मेरे ख्याल से 4-5 दिन पहले भी आया, नहीं देखो, नहीं पता है, इसमें लिखिएगा, मैं साइट ए जजमेंट ऑन सेक्शन 80 खाली लिख के छोड़ दीजिएगा. और तो कोई आपका सबमिशन नहीं.
With exhibit 6 or 7, rent receipt जो filed.
The learned counsel has also submitted that the exhibit 6 and
7, 6 rent receipt, 6 and 6/1.
6 and 6/1 are the two rent receipts. Six and 6/A are the two rent receipts whose photocopy was produced and exhibited before the learned court, but on account of non-production of the original, the learned court has not considered the same. The learned counsel has submitted that the exhibit 4, 6 and 6/A, if taken into consideration, was sufficient to establish the case of the appellant. ठीक बोल रहे? That's all.
Exhibit 7 है.
7 क्या है?
7 general manager Manbom incumbent state acknowledged also that the suit land is under the management of the general manager also during the period till the period 1957 also.
The learned counsel has also submitted that the exhibit 7 was also produced, which was office copy of the letter of Manmohan Singh by Babu Ramanand, General Manager of Manbhum Estate, Manbhum Encumbered Survey State, who according to the appellant had stated, and as per the said letter, the fact that the estate that that the property was under the Manvu encumbered survey state stood established. Okay?
Yes, 28/11/1957. And the
He
same
submits that this letter is dated
3/8/39. No, this is 3/8/39.
3839.
No, 3/8/39.
38/1939. However, the said document is in Bangla.
Yes.
A typed copy of the same has also not been furnished. A typed/translated copy नहीं दिए ना. A typed/translated copy of the same has not been furnished before this court. However, the fact remains that the entire case of the plaintiff revolves around the unregistered settlement dated 9/4/1934.
34.
A photocopy of which was exhibited, but original was not filed. And the reason for not filing the original has been sought to be explained by witness number 1 examined on behalf of the plaintiff, as discussed above. That's all.
One or ground.
आप बताइए.
The Jamabandi which was cashed by the state lordship, since the Jamabandi was open in the favor of the plaintiff lordship, and they have not prepared any appeal or revision against that.
The learned counsel for the appellant has also submitted that the Jamabandi was opened in favor of the plaintiff, and nobody preferred any appeal against the same, and therefore the opening of Jamabandi had attained finality. However, during the course of hearing, it transpired that no order regarding opening of Jamabandi was ever produced or exhibited by the plaintiff before the learned court, nor the Jamindari returns were filed as exhibit before the learned court. दो तो चीज नहीं है ना?
Return ही करो बस receipt we have filed also. It is exhibit 6 also.
नहीं, मतलब वो तो नहीं फाइल हुआ ना?
Return नहीं.
रिटर्न भी नहीं फाइल हुआ और ओपनिंग ऑफ जमाबंदी का कोई ऑर्डर भी नहीं फाइल, करेक्ट?
Yes. And the plaintiff are still in the possession lordship as per section 21 of the CNT.
The appellant has also claimed that the plaintiff is still in possession.
He is an occupancy right lordship.
Sorry?
He is in occupancy right lordship. They are still.
इतना कहानी नहीं हो सकती, जो आपका रिकॉर्ड नहीं है उसके बाहर का कहानी नहीं सुनो. The learned counsel appearing on behalf of the respondent state has vehemently opposed the prayer and has submitted that the learned trial court has considered every aspect of the matter as argued by the learned counsel for the appellant and has also disbelieved the story of the defendant number 1 regarding loss of document by citing numerous reasons, including the fact that no FIR was lodged in connection with the loss of document. The learned counsel submits that Exhibit 2 is an affidavit sworn before notary public, and neither the notary public has been examined nor his register showing the swearing of affidavit on a particular date has been exhibited before the court. The learned counsel has also referred to Exhibit 2 and has submitted that as per Exhibit 2, it was stated that the PW1 had left huge cash amount, ornaments, utensils, and when he came back, they were missing with some important files. And it was apprehended that Prithviraj Singh and his associates had committed some mischief through Swapn and Savitra. The learned counsel has submitted that serious allegations were made in the affidavit sworn before notary public by the election 2, but the plaintiff witness number 1 did not choose to take any steps to lodge any FIR, and although the persons who could be accused in the case were specifically mentioned in the affidavit. The learned counsel has submitted that once the learned trial court has taken a view based on appreciation of materials on record, the said appreciation cannot be ignored even by the first appellate court. And in order to reverse a finding by the first appellate court, reasons are required to be assigned. Since the reasons are sound reasons, there is no occasion to differ with the findings recorded by the learned court. He has also submitted that in absence of production of original settlement deed, which was a deed dated 9/4/1934, which was vehemently opposed by the defendants in the written statement, and also in absence of the original red receipt filed before the authorities, and further in absence of any order regarding opening of Jamabandi or filing of any document, particularly the return filed by the landlord at the time of vesting. The entire story, the plaintiff has failed to establish his case as pleaded in the suit, and therefore the plaintiff was not entitled for any relief in connection with right, title, interest or possession with respect to the suit. after hearing the learned counsel for the parties and considering the facts and circumstances of this case and the arguments advanced, the points for consideration by this court would be the issue number seven, 8, 9, ये इस इशू को छोड़ देंगे, रोमन 3 को छोड़ देंगे, रोमन 4 को छोड़ देंगे, रोमन 5 को छोड़ देंगे, रोमन 6 तो रहेगा। वैल्यूएशन वाला तो डिसाइड हो गया था ना, वैल्यूएशन डिसाइड हो गया था, but still this Roman 6 has been decided against you. Property value. Suit property is not properly valued. It's not properly valued. One, 2, 6 to 11. Valuation पे क्या बोलना? You have not advanced any argument on valuation.
Since we have instituted the suit for declaratory suit clause, so proper ad valorem court fees was paid out.
Ad valorem court fees, they say that the valuation was much more, and as per your case only it was 35,000 per acre. The plaintiff himself at paragraph 35 of the plaint, the circle officer has fixed the valuation at the rate of rupees 35,000 per acre. Chal. This court finds that the main issue involved in this case is issue number is as to whether any deed of settlement was executed on 8/4/1934 and whether by the said deed of settlement any rayati interest in respect of the land mentioned therein was created in favor of the settler. And further, whether the Jamabandi number 61 was validly opened and whether the order dated 14/8/84 cancelling the said Jamabandi was illegal and without jurisdiction. So far as the claim for settlement by virtue of deed dated 8/4/1934 is concerned, it is an admitted fact that it is an admitted fact even from the side of the plaintiff that same was an unregistered document. Admittedly, the the admittedly the original of the same was not exhibited before the court, and the reason for not exhibiting the original before the court was exhibit 2, wherein the PW1 had sworn an affidavit that he was admitted at Purulia on 24/2/1991 at nursing home for operation, and he came to his residence on 12/3/91. And S. Manna and his newly wedded wife Savita unlocked the various original documents which were found missing, and a list of such documents was also mentioned. Which included the original patta dated 9/4/1934. इसमें रेंट रिसीट का जिक्र नहीं है, चेक करिए.
Yes, rent receipt is not in para 1.
नहीं है ना, but there was of any rent receipt having been found missing, including exhibit 6 and 6/1, whose photocopy was exhibited by the PW1. Further, the said affidavit before notary public revealed that S. Manna and Savita, who were in charge of the entire residence of PW1, wherein PW1 had left huge cash, ornament, utensil, and house affair, and they were missing with some important files. It was apprehended, as mentioned in the said affidavit before notary public exhibit 2, that Prithviraj Singh and his associate have committed some mischief through Swapna and Savita. However, admittedly, no FIR was lodged in connection with such serious allegation made and referred to in the affidavit sworn before notary. this court further finds that the PW1 in his evidence has
However, in his deposition, he admitted that the original receipt was in his custody also. Para 11 of his deposition.
the PW1 in his evidence has mentioned about the aforesaid exhibit 2 in order to explain as to why the patta has not been exhibited in original. Apart from that, other documents were also apart from that, photocopy of other documents were also marked as exhibit, citing the same reason. So far as exhibit 6 and 6 by A is concerned, the photocopy was exhibited by stating that the original of this were in his custody and he had handed it over to D.P. Singh, Secretary of Raja Manmohan Singh, who had lost it. However, the Secretary of been examined as a witness. Has he been examined as a witness? Confirm करें. So, as per his deposition, numerous documents were stolen, for which he relied upon Exhibit 2 and Exhibit 6 and 6 by 1, which were the rent receipts in Bangla, said to have been issued sometimes in the year 1937, were also not produced by stating that it was lost by D.P. Singh, Secretary of Raja Manmohan Singh. Further, D.P. Singh, the Secretary of Raja Manmohan Singh, was also not examined in the case. A photocopy of the letter number 51 dated 29/10/1956 was exhibited and identified as Exhibit X. and was marked X for identification. But original of the same was not exhibited, and further the defendants had categorically denied the existence of such document in their written statement. It is important to note that the defendants had raised serious objection regarding non-filing of the documents along with the plaintiff in their written statement, and had also stated that the objection in connection with those documents will be raised as and when the original is produced before the court. But original of the most relevant documents, particularly the Patta dated 9/4/1934, and also the rent receipt exhibit 6 and 6/A were never produced, and the very basis of the claim of the plaintiff could not be said to have been proved without production of the original documents, merely because those documents have been marked as exhibit without objection. The same does not dispense with the proof of the document. And further, this court finds that neither the notary public was examined before the court. Had he been examined, at least his register keeping a record of the affidavits being sworn before him could have been exhibited. But no such step was taken. Further, in spite of serious allegation of theft made in Exhibit 2, no FIR was instituted. And Exhibit 6 and 6/A was not mentioned in Exhibit 2, being the list of stolen documents or articles. But with respect to Exhibit 6 and 6/A, the only explanation furnished was that it was handed over to D.P. Singh, who had lost it. But neither any FIR lodged by D.P. Singh has been produced, nor D.P. Singh has been examined before the court to substantiate such a claim. nor there is any communication or document to show between the PW1 and DP Singh with regard to the loss of original document exhibit 6 and 65A. This court finds that neither the Sada deed of settlement dated 8/4/1934 was and the rent receipt pursuant thereto have been produced before the court, nor there is any cogent explanation for non-production of the same. The learned court has rightly disbelieved the story set up by PW1 regarding the loss of documents and filing of photocopy of the said documents. This court has gone through the entire discussions made by the learned trial court in paragraph 12 by deciding issue number 8 and 9 and upon perusal of the records and the materials on record, this court finds that every aspect of the matter has been duly taken into consideration. This court finds that the plaintiff, this court finds that in the judgment passed in the case of Ugni Devi hai na? Unregistered patta. In the case of Ugni Devi, it has been held that though unregistered patta is not admissible in evidence, but if it is coupled with issuance of rent receipts, coupled with issuance of zamindari rent receipt, the same would be an evidence with regard to the nature of possession of the property.
That is reported 1968 page 1.
Okay. In the present case, the sheet anchor of the claim of the plaintiff was the unregistered patta dated 9/4/1934. Though in the plaint it has been mentioned as 8/4/1934, and the same was not exhibited in original and therefore was not proved. So was the situation with the rent receipts said to be produced by the said to be issued pursuant to such settlement. The plaintiff has failed to prove his settlement through the patta dated 8/4/1934 and even the possession pursuant to such patta as the original rent receipt was also not produced. Therefore, the plaintiff has failed to prove the existence of settlement said to have been executed on 8/4/1934 and consequently has failed to prove his right, title, interest and possession pursuant to such settlement patta dated 8/4/1934. This court also finds that so far as the validity of opening of Jamabandi number 61 and 61 is concerned, the same was admittedly cancelled by the order dated 14/8/1984. The plaintiff has not even exhibited the order of cancellation of Jamamandi. Further, the plaintiff has not exhibited any document, any order regarding opening of Jamamandi in their name, nor the returns of the landlord has been exhibited, which must have been filed at the time of vesting. The returns of the landlord would have thrown some light with regard to right, title, interest and possession of the plaintiff, if any, as the plaintiff is claiming rayati right over the property. In absence of the return, coupled with order opening Jamabandi in the name of the plaintiff pursuant to vesting, merely the fact that Jamabandi was opened in the name of the plaintiff was not sufficient to establish any right of the plaintiff with respect to the property. In such circumstances, once the very basis of the right of the plaintiff, based on unregistered settlement dated 8/4/1934, and also dated 8/4/1934 was not proved, the claim of the plaintiff with regard to opening of with regard to right, title, interest and possession and the opening of Jamabandi
Possession was not there.
just a moment, and opening of Jamabandi in accordance with law was not established. Since the order by which the Jamabandi was opened has not been exhibited, the argument of the appellant that the order opening the Jamabandi would have been challenged and was not challenged is also not sustainable in the eyes of In view of the aforesaid facts and circumstances, this court finds that the London Trial Court has passed a well-reasoned order judgment while deciding issue number 8 and 9, which does not call for any interference. So far as the issue number 6 is concerned, the Learned Trial Court has recorded a finding. So far as the issue number 6 is concerned, the Learned Trial Court has recorded that as per the plaintiff himself, in paragraph 35 of the plaint, देखिए तो पैरा 35 में है क्या? 35 of the plaint, the circle officer had fixed the valuation of the property at the rate of 35,000 per decimal.
That is रिश्तेदारी court lawsuit. Suit for declaration and invention lawsuit. Plaintiff filed suit wherever 862 rupees.
As per Sirista report.
Yes, sir. Suit has been valued at rupees 5,559 rupees. Deficit for
तो बाद में उसका वैल्यूएशन का ऑब्जेक्शन नहीं हो सकता है? हो सकता है ना? सूट का वैल्यूएशन कैन बी अ मैटर ऑफ एडजुडिकेशन आल्सो.
yes, sir.
यस. पैरा 35 में आप बोले हैं ना प्लेट पे, कल ये चेक करें.
Circular officer has fixed the valuation of lands to be settled in favor of Department 6 at the rate of rupees 35,000 per acre.
Paragraph 35 of the plaint is quoted as under.
Per acre as salami.
So, and serious objection was taken by the respondents, by the defendants in the written statement, that with respect to valuation of suit at paragraph 44, in paragraph 38, that the market value of the suit land was over rupees 35,000 per acre, and unless the suit is valued afresh by giving market value, it could not proceed. This court finds that the learned trial court has rightly taken into consideration the aforesaid aspect of the matter, and has held that suit was not properly valued. With respect to the notice under section 80 तो हो गया complete. This court finds that the learned trial court has rightly recorded that so far as issue number 1 is concerned, the learned court has recorded that there was no cause of action to file the suit. However, since the Jamabandi was admittedly cancelled, therefore it cannot be said that there was no cause of action for the plaintiff to seek a declaration to the suitor. Consequently, the finding of the learned trial court with regard to cause of action calls for interference, and this issue is decided in favor of the appellant and against the respondents. Cause of action तो आपको so far as issue number 10 and 11 is concerned, the learned trial court has rightly recorded that the plaintiff has failed to establish his rayati interest over the suit property. And those issues were decided against the plaintiff. This court is of the view that this was again recorded by referring to Exhibit 4. This court is of the view that the learned trial court has rightly held that the plaintiff has failed to establish the interest over the suit property, and consequently the same has rightly decided. As a cumulative effect of the aforesaid findings, this court is of the view that there is no merit in this first appeal, and impugned judgment does not call for interference except with regard to issue number 1 regarding cause of action. This is
For Frank Suraj, 1 from supplementary list, second April 21 of 2022.
recorded.
First of all, I'll ever be grateful for yesterday's.
Oh, yes, that's yes, we are always there.
Now I'm starting with the.
Children are the future of our nation. They have to be taken care of at all cost. वो breed खराब हो जाएगा ना, सब चीज खराब हो जाएगा.
May I read the substantial question of this? Order dated 6/25.
Yes, please.
Para 2. The learned counsel for the appellants has submitted that the appellants are tenant in the suit premises and the predecessor in interest of the plaintiff had executed the agreement of sale with respect to the suit premises, and the title suit was going on in connection with specific performance of contract. In the meantime, one of the successors of the original landlord executed a sale in favor of the plaintiff, and the plaintiff claimed that he had inducted the defendant as tenant in the suit premises upon payment of monthly rent at the rate rupees 300. The learned counsel submits that once the suit for specific performance of contract was pending in connection with the suit premises against the original owner of the property, there is no question of fresh tenancy, as the appellants who were the tenant acquired title over the property by virtue of part performance, as they were already in possession of the property, and therefore there is no question for any default in payment of rent, even if the property was sold pending suit for specific performance. The learned counsel further submits that where both the parties were claiming title over the property, the suit under Bihar Building Lease Rent Eviction Control Act was itself maintainable. The learned counsel submits that this appeal is fit to be admitted on substantial question of law as follows: whether the appellants acquired title over the property by virtue of part performance of agreement of sale and were put in possession, and therefore whether they were under any legal obligation to pay rent to the successor in interest or even to the vendor of the plaintiff, whether the suit under Bihar Building Lease Rent and Eviction Control Act was itself maintainable, where both the parties were claiming title over the property. Ladyship, first and foremost thing that we have to look into is whether there was tenancy between the parties or not. Both the court below, they have come to the finding that there was a relationship of landlord and tenant between the parties. I understand the limitation of second appeal edition when there has come a fact with respect to the tenancy running in their name, the scope of interference to that respect. Ladyship, however, how this finding has come, whether my evidences which I laid before the court below, that has been considered in the right perspective or not. Thirdly, half of the story they have taken from my WS, half of the story they have taken up from the plaintiff claims. That cannot be possible, ladyship. Either the plaintiff has to sustain or the WS has to be sustained. What they have saying, when my particular case is that I was in possession of that particular land since 1967-69, and In 2003, a agreement for sale was executed, and thereafter a specific performance act under that suit is pending. Now, the court has come to a finding that yes, I was in possession, but the story of the plaintiff, the very plaintiff says that I was inducted as a tenant in 2006 when a room was constructed and it was handed over to me.
You just give me the timeline.
Yes, Leadership.
Is it your admitted position that you were initially inducted as a tenant or not?
It is my admitted possession.
What is the date of tenancy according to you?
Leadership, this is a small list of
Give
dates.
me.
Very small fact, Leadership, in the second page, second point, this is the case of the
Can you
plaintiff.
read it entirely?
Yes.
Plaintiff's case, right?
Yes. Suit property schedule A, land such and such, such and such.
Any dispute on this?
No.
Next.
Suit property is itself acquired property of plaintiff by virtue of sale deed number 165/145 dated 9/3/2006.
Any dispute on this?
Yes. This is the contention lies. Now the plaintiff came in possession of the suit land, again disputed because we say that he was never in possession.
Possession means?
Possession over the suit property. He never had the possession over the suit
You were the
property.
tenant over the property.
I was at the tenant.
Since when?
67, 69.
Only defendant?
No, two defendants. My brother and myself. Well, two defendants are there. Defendant number 2 is one of the brothers and defendant number
In possession since 67, 68. On rent?
on rent.
On rent. Who was your previous landlord? The vendor of the plaintiff. The vendor of the plaintiff must be your previous landlord.
No, Leadership. What they say.
Vendor of the plaintiff is not the plaintiff. His father, their case is that Tarni Prasad Shah.
बहस करने दीजिए क्यों आप ऐसा कर रहे हैं? हाँ बोलिए.
Leadership, how the land has come in the what is this their case for that? The genealogy has to be seen.
Yes.
The suit land is 16 road, purchased by one Pachia, Musawwat Pachia. She had two sons.
Two
Sons, yes. Son one is Udheshwar. Son two is Jogeshwar. Udheshwar, son one, he died issueless. And he had adopted one Kedarnath. Now coming to son two.
Kedarnath.
Yes.
The son too.
Son two is Jogeshwar at the rate Jogarnath. He had two sons, Tarini Shah and Anuruddha. Tarini Shah died in 2004 and his wife is Shanti Devi.
Died 2004. Wife is Shanti Devi.
Wife is Shanti Devi. And Tarini Shah and Shanti Devi had 4 daughters, one son, Basudev Shah. Son's name is Basudev Shah. My case is that he was mentally ill. And Basudev Shah's wife is Kalyani Devi. Anuruddha had, either Jogeshwar had 2 sons. Son 1 is Tarini Shah that I have explained. Second son is of Jogeshwar is Aniruddha. Anuruddha again had 2 sons, Krishna and Kedar Shah. Now this Kedar Shah was the adopted son of Udeshwar, that was son 1 of Pachia.
Kedar Shah, Kedarnath.
Kedar Shah, Kedarnath.
Alias नहीं.
हाँ, alias कर.
हम नहीं करेंगे.
But नहीं है, हम आपको दिखला देंगे ना. मेरा WS से I'm saying what I'm saying.
WS से नहीं दिखाई ना, आप जजमेंट से दिखाई. सेकंड अपील में जजमेंट से देखी.
हाँ, हम सब दिखला देंगे. It is, and they have not cross-examined me on that point. Nowhere. Now, how
Who
the
is the vendor of the plaintiff?
yes, now coming to who is the vendor of the plaintiff is, they say that Basudev Shah was the vendor of the plaintiff, who is son of Tarani Shah. जो
Who was
second-
mentally ill according to you?
Yes, for according to me, he was mentally ill. Now, secondly, ladyship, if the property, which was an ancestral property, has flown from Tarani Shah to Basudev Shah, other co-sharers, they have not executed the sale deed. So at best, he could have executed his own property, his share. Secondly, we have specifically taken a plea that Basudev Shah was mentally ill. Somewhere it has been mentioned mad, somewhere mentally ill, whatever. We have led evidence to that respect. My documents and in my WS, I have deposed, the others have deposed, they have never cross-examined me on that point. So, their title itself is under cloud
So
leadership.
this title deed has been challenged.
This title deed, we say they have brought in.
Anybody has challenged it?
No, that we have straight away stated in this that
It can't be like this, no? Whenever there is a title deed, it has to be specifically challenged. Otherwise, it will stand as it is. Unless the deed is specifically challenged, particularly in a case where you say that the vendor was mad, it requires full-fledged adjudication. Anyways, this deed is staring at you. It's an eviction suit under BBC Act.
yes,
right? So
yes.
this deed is staring at you. You had this kind of objection so
Yes.
far as this deed is concerned.
Yes.
Who
Now-
has transferred the property to you?
Yes, but the property has been transferred to me. Part performance was performed
By whom?
it was Tarani Shah. And in that
When?
2003, prior to this 2006 sale date. Now I'm coming from again to the list of dates leadership from that it will clear. This was
2003.
in
Any
2000.
registered document?
No, it was not a registered document.
There was an agreement for
There
sale.
was an agreement for sale.
You exhibited that.
Yes, I have exhibited.
So you just tell us
Yes.
that when you are talking about part, how do you rely upon an unregistered document executed in the year 2003?
Leadership, as far as the title, whether it will flow to me or not, whether the specific performance, I have instituted a separate suit.
Must have. You have instituted a separate suit for what?
For the specific performance against Shanti Devi, who is the wife of Tarani Shah.
Against Shanti Devi, you have instituted a specific performance. of
Yes.
contract. For execution of the
Yes, for execution of her part and executing a
you
sale
paid
deed.
the entire consideration.
No, a certain amount of consideration was paid.
As per the specific relief, as per section 53A, I think the entire consideration is to be paid, no?
With regard to the protection.
Sorry?
That is with
53
regard
is
to
with
protection.
protection.
53
Ah. In order to claim protection under section 53A, the entire consideration amount is required.
That is also one point. Apart from that, after 2001, it has to be registered. There are number of judgments.
Even below, my question is that to look into the tenancy, the documents, it cannot be said that unregistered document is not admissible.
Since when have you stopped paying rent to anybody?
2003. When we entered into an agreement, I had given money. There is
Was it a part of the agreement that you will stop paying rent and the property stands transferred to you?
the part of the agreement was that the part was given by me. After 1 month, it was to be executed.
Merely because there is an agreement, the title does not pass on to you. Point number one. That by itself does not disentitle you from payment of rent unless there is an agreement to that effect that no further rent will be paid.
I'll just confirm that
इसको
part.
कंफर्म करिए
इसको confirm.
लंच के बाद से जजमेंट से देखते हैं हम लोग
जी
नहीं देखते ना
नहीं
मत देखिए